Hello everybody, we're going to get started on part 2 of freedom of speech. So that you're aware of what we're going to be working from, this is the same file in Obsidian that we had from last time from the intro class on this topic, and we're just going to skip through here. And this is the part 2 section about halfway through. First and foremost, the overview. In this section, we're going to review what rights a person actually has when it concerns freedom of speech and talk about how to help people understand those rights. That's going to be your homework assignment. In preparation for this, I asked you all to submit videos from part 1. And your homework for this class is going to be to complete your discussion boards, which will be open shortly after me uploading this, and submit videos for next week. Without further ado, let's start talking about freedom of speech. As everybody knows, this is part of the First Amendment, and I probably should have put into the notes the actual text of the First Amendment. I will probably go back and add that. In the short term, I am going to read that to you. It states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. The most common two things that people cite are going to be that freedom of religion and freedom of speech portion. When we're talking about freedom of speech, it doesn't mean that you can just say anything you want. When we're talking about the language in particular, the first thing we have to start thinking about is that Congress shall make no law respecting an establishment of religion. We will see in a few minutes how that actually has been expanded to the states through incorporation, but in the short term, what I need you to know is this doesn't apply to private individuals. When we look at the First Amendment, and in particular freedom of speech, the first thing we need to consider is the forum. A forum is going to be where this is said, or where the speech is scheduled to take place. There are 3 types of public forums established by the government. And again, we only care about public forums that are established by the government. To the extent practical, there are no limits on what you can say in the privacy of your own home. And I say this because how are they going to know, right? You know, this really deals with the crimes that happen when you say something in public or when you communicate something in public. It's very difficult for the government to know if you walk around your house muttering things that you know about other people or about terroristic threats or something. They're just not going to know. I say limited, or I say that this is limited because you certainly can say something to somebody that constitutes harassment or assault or something like that, just depending on what you say. There are times when they can punish you for what you say in your own home, but for the most part, if it's not published to somebody else, there's not a good way to enforce it. The government cannot limit speech in open forums. So if we create a park, and in this park we encourage people to come and speak, and there's no real way that they have to sign up or anything like that, the government can't restrict that. Anybody who has a message can go and restrict that. Now, when I say that, the caveat is that you do have to comply with other laws that exist. For example, if you decide what you want to do, your biggest dream in life is to have some sort of nude art exhibition, and you want to do this on the steps of City Hall, don't cite me on this, because while I just told you the government can't really limit an open forum, obscenity laws and stuff would still apply. That said, most places are going to be more of a limited forum. A limited forum is going to be where the government places some limits on the forum. For example, when you can do this, or you have to obtain a permit, or you can only have demonstrations on certain topics. Maybe, for example, the capital for the state of Missouri is going to allow members of the public to come and comment on bills. Well, this is a limited forum. This doesn't mean that you can come talk about whatever you want. It doesn't mean that you can come have your jazz recital in the middle of a Senate chamber. What it means is that you can come for the express purpose of commenting on bills. Finally, there is closed forums too. This is something like the House floor. You can, if you're a member, debate on the House floor, but you really can't do that if you're not. They've got specific rules against it. And as you might expect, the degree to which the government can limit it ratchets up depending on how limited the forum is. The test here is going to be if the government is treating people the same, then it is not, and it's not singling out viewpoints. What's important when we talk about something like an open forum is that we are treating everybody equally. For example, this comes up in education law quite a bit. If we decide we are going to allow students to put up signs on campus, we can't restrict people based on what their viewpoint is. If we say any student organization can put up signs, and we let the pro-choice people put up signs, then we also have to let the pro-life people put up signs. It's a limited forum, sure, in that the university probably requires approval in advance and stuff like that, but we can't exclude people based on their viewpoint only for not complying with the rules of that forum. The classic example of this deals with, we'll talk about the opposite side of this when we get to government speech, but the classic example dealing with this from a different viewpoint than schools is if a courthouse, for example, in a county allows different civic organizations to put up statues. This is a case from a couple of years ago, and what happened was that they allowed some Christian organizations to establish different sculptures, and some Satanists decided that they also wanted to do that. So they went through the normal process, and the county, not surprising at all, said, no, we are not going to let you put this up, and subsequently they sued. This was a open forum. This was something that or even a limited forum, but this was something that the government established where people could communicate, and they were limiting it based on viewpoint. When that happens, it becomes a violation of the First Amendment. Captive audience. There's not very many notes here, but I did want to mention this. You can have an employer that forces their employees to listen to specific speeches. Perhaps they want to talk generally about you not unionizing. They can do this. There are limits. You cannot have a speech about not unionizing within so many hours within 24 hours of having a vote on who's going to be your union representatives. You cannot be unduly influencing. And if you are an employer and you are having such a speech about not unionizing, you have to pay your employees during this time. You can't mandate that your employees come attend a lecture on something and not pay them. So, captive audience, yes, it's okay. It's not a violation of the First Amendment. However, if you are a captive audience, you have to be compensated. Prior restraint. This is when the government bans a particular type of speech categorically. Imagine if you're a legislator, and you don't want people to be able to say anything bad about you. It's very tempting to pass a law that says that you are guilty of a crime if you say anything negative about a elected official. And because of that, this sort of process, this prior restraint, saying that categorically something is not able to be talked about, is extremely disfavored. Courts hate this, but there are a couple of exceptions. First, there are times when we do need to actually not permit discussion about things for national security reasons. For example, maybe you are in the possession of classified information and you decide you want to print that. The government can prevent you from printing that information because doing so would be a clear and present danger. We'll see a case about that later on. But the fact of the matter is that there are times that the government, for national security reasons, can limit what you can say. Second, when the publication could incite violence, it is not acceptable to, for example, try and overthrow the government. And I think it's important here to quickly take a moment and say publication here means to transmit information through whatever means from one person to another. We'll look at this when we get to defamation, but basically whether you print it, email it, say it on a cell phone, or do it face-to-face, to publish something is to transmit it to somebody else. So if we are saying, you should really go kill this person, could you please go kill this person, that could be conspiracy to commit murder. It is not protected under the First Amendment. Finally, when the publication is associated with a school, this is kind of a weird area. School administration has the ability to limit publications that violate school rules, stuff like that. The example of this, for me, something I witnessed, was the school newspaper wanted to run an issue all about sex. And the school administration obviously said, no, we're not going to do that. Because schools are subject to less stringent interpretations of constitutional amendments due to the nature of the fact that it is an institution of the government. They are able to censor the material that school newspapers put out. Similarly, if you're on campus at Lincoln and you want to publish a flyer, Lincoln University does have the ability to limit the sort of information you can publish on that flyer. All right, defamation. So let's say that you say something and it's untrue. Well, we've got a couple of different words for this. Defamation in general covers both these terms. So if we say that you defamed somebody, you could have either libeled them or slandered them. Libel is when you print something that is untrue. So it has to be a physical publication. Slander, on the other hand, is when you say something that is untrue. You can slander somebody and not libel them. You can libel somebody and not slander them. The distinction doesn't really matter. The elements of the offense are the same. First, you have to have made a statement or a publication that is demonstrably false. And it has to result in actual damage to the person that was the target of that statement. And finally, this damage has to be the proximate cause, or it has to be approximately caused by the statement or publication. Let's break this down a little bit further. The theory that you're going to sue under, or the hypothetical case, is going to be something like this. Bob is walking down the street and says to his friend Jane, Stan over there is a terrible person. I heard he murders cats. And goes on and on about what a terrible person Stan is. Stan could sue Bob, and let's walk through these elements. First off, Bob is going to have the burden of proof. Stan is going to have the burden of proof. Stan is going to have to convince the jury that all of these elements are met. First, is there a statement or publication? Well, that's easy. We can have Jane testify that that happened. So that's an easy element to prove. But Stan has to prove that the statement is false. And that can be hard, especially because when you think about it, it's logically impossible to prove a negative. Because of that, defamation cases are sometimes tricky to win. In this case, Stan is going to have to prove that no, he's not a cat murderer and that there's no evidence to support that he ever was. I don't know how he's going to do that, but that's something that he'd have to figure it out. Third is that this has to result in actual damage to the person. If Bob simply says this to Jane, and that's as far as it goes, there's probably not any actual damage. If, however, Jane is on the admissions committee to the local veterinary school and in the next meeting says, oh my God, we can't have Stan as one of our students, he murders cats, and subsequently he is not admitted to that university, there would be some actual damage there. That person would have lost quite a bit because they aren't able to attend the program they want to attend because of Bob's actions. In that case, it's easy. We can prove that there are damages, and then we just have to quantify how much the damage is. But this brings us to the last point, and this is the one that's kind of tricky. That damage has to be approximately caused by the statements or publication. Again, going back to our hypothetical, if if Stan wasn't going to get into the school because he had a 1.2 GPA, despite the fact that Jane conveyed that information, then there might be an intervening cause there. Stan wasn't going to get in anyway. We don't have proximate cause, and therefore there's not a crime. Why does all this matter? This all really comes to effect because while you can say whatever you want typically, the government does permit causes of action for things like defamation and libel. These are not going to be protected under the First Amendment. However, there is going to be decreased tolerance for defamation cases when we're dealing with people who have sought out the public eye. What we mean by this is that people who make themselves famous benefit from being famous, but also aren't going to be as protected. We can say terrible things about Bill Clinton or Donald Trump or Barack Obama or Joe Biden because these people are people that are in the public eye. You can say somebody does terrible things with children or has no intelligence because they are out there seeking that public eye. The fact that somebody may believe you, it may damage the reputation, is to a large extent irrelevant. I will note that some states still have an element of this crime that is malice. I don't really think that that exists most places, but in the Restatement of Torts, it does exist. If you are in a state that has malice as an element, then you have these first four elements, but then you also, as the plaintiff, have to prove that the person meant to hurt you. Think about the way this could go from a different point of view. You could be, Bob and Stan could be the best of friends. Jane could also be a friend of theirs. It could all be a joke, right? No malice was intended. Bob did not mean to get Stan kicked out of veterinary school, nothing like that. In that case, there's probably not a suit for defamation. All right, absolute privilege. A privilege is an immunity, basically. It means that you cannot sue somebody for defamation, and government officials are immune from defamation claims when acting in their official capacity. If the Cole County Sheriff goes on TV tonight and says that Andrew Sartorius murdered 3 children in the wee hours of the morning, he's going to be immune from prosecution, even though what I was doing in the wee hours of the morning is filming this video. So, that's something that we need. We need to protect people who are acting in their official capacity because they have a job to do as part of the government where they need to be free to talk about what they need to talk about. So next, now with this, we've kind of covered, all right, here's what the First Amendment is going to cover when it comes to freedom of speech. We're going to start getting into more of the things that it doesn't protect. One of the first things it does not protect is advocacy of illegal action. This may be prohibited, but really depends on how it is said. A bomb threat, for example, is going to be very different than something like "let's take back the streets." Both of these statements could be advocating for illegal action. A bomb threat, calling somebody and saying "I'm going to blow up X building on Y date," is a lot worse than saying "let's take back the streets." "Let's take back the streets" could imply some violence, but it also might not. And to the extent that we're going to protect speech, we're going to protect things that allow people to make emotional or powerful statements like that. Fighting words. This is almost never going to be allowed when it's meant the right way. If I were to say to a student, "why I ought to slap you," nobody's going to probably take me seriously. First off, you're not going to take me seriously because you're watching this on YouTube and there's no physical way I could reach through the screen and slap you. Second, that's not me. I joke about it. I might joke about it, but I'd never actually do it. So if you say it jokingly and everybody knows it's joking, it's probably protected speech. But you can't threaten people or incite violence. So if I'm actually committing the crime of assault the tort of assault, the crime would be also probably assault, but depending on what I actually did, if I'm actually threatening you, if I say I am going to come to your house and hurt you, that is going to be speech that is not protected. In this case, it's protected. I'm using it as an example in my lesson to talk to you about something that wouldn't be protected. So you can't threaten people. Similarly, you can't incite a panic. You can't be in a crowded movie theater and say "fire," or, as we're going to see in a minute, be on an airplane and yell "there's a bomb on the plane, there's a bomb on the plane." So fighting words, not permitted. Commercial speech. Companies, to some extent, are going to enjoy their right to freedom of speech as well. Nobody is telling Target they can't advertise. However, there are going to be some limitations here. In particular, there are lots of things that are designed to protect the public from deceptions that companies might employ. For example, companies can be punished for misleading statements. In Missouri, we have the Merchandising Practices Act or the Consumer Protection Act. And if a company makes a misleading statement or a material misrepresentation, is what the statute says, before, during, or after the sale of goods or services, you're entitled to sue them. This could be considered freedom of speech, but it's waived because you're engaging in a commercial transaction, and we need some presumption that you're actually telling the truth. Government speech. The government gets to speak too? Absolutely. The case that deals with this is another statute case. In this case, the government is a small town, and they have a city park. In the city park, the government erects, at the government's expense, various statues. A satanic group, again, comes to the park and says, "Hey, we will give you the money to put up this statue." And the city government says, "No, thanks." This is very similar to the case we talked about earlier dealing with statues, but the difference is that in this case, it's the government speaking. This is actually protected under the First Amendment because the government is expressing the viewpoint of the government. It seems bizarre, but they haven't created an open forum. It's a closed forum. And that speech that they're engaging in is completely fine. Notably, they haven't passed a law dealing with the establishment of a religion. So that's kind of where we draw the line to, which will get us into next week too. If they would have created an open forum, though, if they would have had some statues that were donated and some statues that were bought by the government, this would be a completely different story. Here, because it's not an open forum, they don't actually limit speech. Obscenity. This can be limited, but the standard is getting harder and harder to meet. Back in the day, if you were to say something rude to somebody, that could be considered obscene. But with the way that we engage in material and stuff like that now, that standard has been shifting considerably. The best example is art versus pornography. Art can't be limited. For example, if you go to the St. Louis Art Museum, they have an entire wing with nudes. Nude statues, nude paintings. That's art. It's displayed in a public place. Even things that look pretty realistic. But pornography can be limited. You don't walk down High Street in Jefferson City and see shops selling pornography. You don't see pictures of naked women on billboards like you might see in Europe. The question, therefore, is what is pornography? What's the difference? Famously, the answer is we will know it when we know it. There's not really a good definition here. Basically, the question the court's going to ask is, does this have some sort of artistic value? We can't write a hard and fast rule, but we will know what pornography is when we see pornography. So obscenity can be limited. All right, so now we're going to get into some different court cases and different tests that have been applied and talk about how the courts deal with freedom of speech. When it comes to inciting violence or what speech is going to be allowed and what fighting words aren't going to be allowed, there's a two-pronged test. And lots of times when we talk about tests, there are going to be tests that you have to meet some criteria in it, or there's tests where you have to meet all of the criteria in it. There might also be things where you have to balance different interests. When we talk about a two-pronged test, that is going to be a test that you have to satisfy both elements of. So, if we have somebody who uses some fighting words, like we're going to take back the streets tonight, the speech is, in order to be censored, or in order for the government to consider it illegal and not violate the First Amendment, the speech has to be directed to inciting or producing imminent lawless action, and the speech is actually likely to incite or produce such action. Me saying we have to take back the street tonight could go either way, right? It's going to depend on the rest of the contents of the speech. If we talk about, for example, protecting women and trying to set up safety nets and have like sober drivers and stuff, and we call it Take Back the Night, that's going to be different than if we talk about, all right, Bob's got the crowbars and you've got the gasoline and we're going to take back these streets any means necessary. So, that's the Brandenburg test. And realistically, just don't incite violence. It's probably not a good idea. It doesn't work out well. All right, Schenck versus the United States. This is a case from 1919. And the question is, can a person disseminate leaflets advocating that people protest the draft. What we're going to see over these cases is starting with really harsh rulings and moving to more and more leniency. In this case, this dude, Shank, decides that he doesn't want people to be drafted, and he advocates that people engage in civil disobedience. But this violates an anti-espionage act, and the fear is that it is going to cause disorder in the ranks and that the military is not going to be effective. The Supreme Court holds and establishes this clear and present danger test. Because what he's doing is a clear and present danger to the defense of the nation, it is going to be a violation of the First Amendment. Next, we have Gitlow versus New York. In this case, the holding is that the government can prohibit people from asserting that others should violently overthrow the government. Gitlow, more or less, was publishing pamphlets that were telling people they should revolt against the United States and establish a new communist way of life. That didn't go over so well. The pamphlets didn't do so great, but it doesn't matter under this case how much traction the particular thing got. What matters is that he was doing it. Interestingly enough, though, this Gitlow versus New York case also is very important for another reason. This is where the court first begins incorporating elements of the Bill of Rights into the states. So while Gitlow lost, it's a pretty good procedural case otherwise. Roth versus the United States. This is the case that says that the government can prohibit the distribution of offensive materials, such as pornography. But in subsequent cases, the definition of what pornography is was significantly lessened. So in the beginning, it was anything that basically didn't add value to the conversation. Later on, they removed that, and it is much easier. Again, the trend is that it gets harder and harder to restrict information. Texas versus Johnson. And this is kind of where we see the full swing of things. In Texas versus Johnson, Johnson is a guy who wanted to protest something and burnt a flag. But the Supreme Court basically changed their view and held that the government cannot ban speech just because society holds it to be disagreeable. This is why we have neo-Nazi marches, Ku Klux Klan marches. Even though society as a whole, or the vast majority of society, may disagree with a particular viewpoint, that is not going to be reason enough to ban anything. So let's talk a little bit about some of the videos you submitted. For those of you, and the response was not overwhelming, please do better next time. What I'm going to do, so I don't violate YouTube's copyright agreements and have to find some other way to host these videos, is allow you to watch these on your own, but I'm going to talk about kind of my thoughts on them. The first video we have deals with an insane person who's yelling at people in a store, and then it has some commentary at the end from a local attorney. As we'll often see, there are two sides to everything. And in this case, the good news, whether you like it or not, is that this is actually protected speech. You can yell at somebody. This woman wasn't threatening to hurt them. She wasn't saying anything that was, fighting words or inciting a panic or anything like that. While it's extremely distasteful, it's not unconstitutional it's going to be unconstitutional to limit this speech. I don't agree with the attorney who's saying that this is assault. It's going to really depend on the state you're in. In Missouri, this would not be harassment. I'm sorry. I don't agree with the attorney who said it's harassment. In Missouri, this wouldn't be harassment. Harassment requires a pattern of behavior. In this case, there's not really a pattern. This is happening once. It's nuts, but it happened. So that's the good news from a constitutional standpoint. First Amendment protects it. However, the good news from the other side is that the mall banning her does not violate the First Amendment, as they're a private business, not part of the government. Remember, when we read the definition, or I'm sorry, when we read the text from the First Amendment, it said Congress shall pass no law. Not that private citizens can't prevent private citizens from speaking, or private citizens can't close a forum they have established to other private citizens. It says that the government can't do it. So in this case, the mall banning this individual doesn't pose a problem at all. Our next case deals with a guy on a plane who is screaming about how there's a bomb on the plane. And again, great example. This guy might argue that he was exercising his right to free speech. However, this one's easy. It's similar to shouting fire in a movie theater. If you say that we're going to blow up the plane, that is something that is going to terrify people. It poses a clear and present danger. It doesn't matter what standard you apply. What matters is the fact that this guy is scaring the hell out of people. It's going to be bad. It's therefore not protected under the First Amendment. He is most certainly either in a psychiatric institution or in a federal prison. Depending on the date. Maybe he's awaiting trial still. I am not going to play this for sure. This is a TikTok. You are welcome to listen to it if you want, but it consists of some sound bites from South Park with this guy acting it out. And we're talking about profanity. Is this type of speech protected? Sure it is. It aired on Comedy Central. It aired it after a specific time due to FCC regulations. Basically, when you have extremely profane speech like this is going to be protected, but it can almost certainly be limited depending on the forum you're in. Would this sort of speech be tolerated in a school? No. If you went to the United States Capitol and started saying the things that are in this video, would you get arrested? Yeah, you would. But it also aired on TV. So this is a great example of how the First Amendment is going to protect it depending on what forum you are in. This one, and I apologize for how it cropped this one is nuts. It is a Dr. Phil episode, and there is just so much to cover here. First and foremost, there's a lot of change going on in our country, if you haven't noticed, dealing with what people consider appropriate. Terms are changing all over the place. On GitHub, for example, a software repository site, we used to call the main thread the master thread. Now it's called the main thread. We have changed football team names. All kinds of things are changing to try and be more inclusive. However, classifying the changes in words or the changes in what we consider appropriate as a First Amendment issue is to a large extent incorrect. There's been a lot of talk about cancel culture, and the fact that people or society or a good number of people are saying we don't want people who are using this terminology, that's not unconstitutional, that's change, and it happens. It's going to happen. It's going to continue to happen. But this video does bring up an interesting freedom of speech issue, and it could be a violation of the First Amendment, but we don't really know all the information. Dr. Phil does an interesting job of getting some of the facts, but we don't really know what happened on the inside. And okay, sorry about that. I had to fix the formatting so we could actually see what's going on. So going back to what we're actually talking about here with the students, the freedom of speech issue presented in this case could be a violation, but again, we don't have all the facts. Campuses are interesting animals when it comes to talking about First Amendment issues, because since they're a school, the administrators are going to have a lot more power to decide what sort of language comes up. Additionally, they can change their mind. This may be something that is shocking, but when the students in this video are complaining about the fact that they already got approval for these, if the number one, I'm sorry, let me back up. They already got approval for these. The number one function of a campus, just like the number one function of a school, is to educate. So if there is something that becomes disruptive to the learning experience, they can change their mind on allowing it on the campus. In this case, they have a designated space for this sort of information to be published. They continue to allow it to be published there, but they removed it from areas where it might be disruptive. Did they do the right thing? I don't know. It seems like they may be pursuing litigation. We'll have to keep watching this one to see what happens in the future. So thanks everybody who submitted videos. What's coming up next? First, I will, by the end of the night, so before you see this video, probably have your discussion boards open. When you're commenting, and remember, you're going to do one original post, and you're going to do 2 derivative posts. So you'll post once your own idea, and then you can comment on 2 of your classmates' ideas. If you want to be an overachiever and do 2 or 3 of your own original ideas, by all means, please do it. The things I have no limits on what you want to talk about in the discussions. However, I do encourage you to consider these 3 questions. Why are people misunderstanding the First Amendment? What are some ways that we can help teach them what actually exists? And I'm sorry, these 2 questions. I saw the line below and got excited. After that, what we're going to talk about next class is freedom of religion. There are going to be 2 ways for you to submit your videos like last time. First, you can submit them by clicking this link, which is going to open this page below, and just drop your files here. They'll be uploaded to my file store, and I will be able to access them from there. Be sure to put your name in this box right here so that we can make sure and get you credit for getting that done. Everybody, thank you so much. You are doing such a great job this semester. If you have not gotten your videos in for the freedom of speech thing, don't worry about it. There's going to be plenty more opportunities for you to make up the points in the coming weeks. If you have any questions, as always, please feel free to call, email, text, message me on Snapchat. I'm sorry, message me on Canvas. I don't use Snapchat, so your message will never get responded to on there. And have a great night.